Professor Akpe, good afternoon, sir.
Able chair, I bow and tremble at your feet.
Oh, not at your feet, at our feet.
I am humbled, sir. I am humbled. Thank you so much for all the professorial work that you are putting into this committee. We're truly appreciative.
We thank the chair for his able leadership, and we thank most esteemed guest speaker for her time. We know how we don't take it for granted. We know how much this would have cost us if we were not coming under this kind of platform. So we are very grateful. And chair, sir.
Yes, sir. Alternate chair.
Yes.
I'm talking about the branch chair that says she's being joined today in good company by equally pretty presenters, so they will all make a good team.
Oh, yeah. We are also privileged. In fact, I even got a call from the US, a colleague from the US saying, oh, they'll be participating in this webinar. I said, wow. Yeah. Our guest speaker is really, really international and attracting so many participants to this meeting.
Yeah. So in the next 5 minutes, you should start.
Yeah.
Emilia, how much time do you need?
Let me be sure. Oh, okay. So can you hear me?
Yeah, very well.
Oh, okay. I was thinking, I think we have a total of 2 hours.
Yeah.
I was thinking maybe an hour, 45 minutes, an hour, 50 minutes for the group work, everything anyway. But that's fine. Howsoever much time we have, we will conclude.
Okay. Chinelo. Is Sam there now?
I think, Chair, I think you need to explain to Emilia. I think what you were asking of, you wanted to know how much time she would take to make her presentation, and then how much time will be allotted to her intervention, questions, and answers.
That is correct. I want to ensure that the moderators are there before I continue. Chinelo, is Sam there? Chinelo? Chinelo? Sam? We had this challenge the last time that I lost the 2 moderators. Sam?
Not yet. He's not here yet.
Okay, if he's not here, you take over. You take over and do everything yourself.
No problem.
Okay, so Emilia, out of our 2 hours, we'll an hour 30 minutes for you for delivery, then 30 minutes for Q&A.
Oh no, the 1 hour 30 minutes will be enough for everything, including.
Okay, the Q&A.
So when I said 1 hour 45 minutes, that would include the presentation, the Q&A, everything, because everything rolled into the slides.
Okay. You have the program
as well.
Hello.
Chinelo.
Yes, Prof.
At 2 o'clock we'll start. At 2 o'clock we'll start, please.
No, log in with the link that went with the flyer. Yes, I do. I'll work with the program.
Okay.
Yes,
okay.
Prof. I'll work with the program.
Well, Prof. Hakme said, since it's my area, I should act as chair for today, much against my aim. I thought since I'm away, he should take full charge, but he said that he yields today to me, but the training for next month, he will be fully in charge. So I will act as chairman.
Okay, it's 2 o'clock.
Yeah.
Welcome, distinguished gentlemen of the inner bar, the outer bar, and to you all the world over to this training. In no particular way, I would recognize everyone on the platform. You're welcome, Professor Emilia Oyema. Welcome, Professor Paul Idamige, Professor Peter Ape, Ade Nipekun,
Yes, thank you.
Ado Dahiru, Ahmed Olaniyan, Ahmed Yabo. It's a whole lot. We have 55 people logged in now. Akin Labi, Akin Bade, Alozie Echeorun, Anayok Sipran Ilo, Antonia Umberi. I beg your pardon if I pronounce your name the wrong way. Okay, so we have Ekoma Bonilobi. We have Chariots, Bate. We have Audu, Chinelo, Wendu, Brown, Covenant, Eloho, Emad, Emanuela, Amy, Femi, Hallelujah, Happiness, Johanna, Jolie, Josephine, Jumoke, Mary, Mirabel, Okechuku, Raphael, Rolly, Som, Temitope, Titus, Aisha, Hawa Shakarau, the chairman of the branch, Oke Obi, and Zainab Suli. Thank you so very much for joining this webinar today. Well, arbitration, being the most commonly used alternative dispute resolution mechanism by parties, does not require any long procedures of the courts for the decisions to be made. However, whether arbitration is the best way to resolve a legal dispute depends on the relevant circumstances and considerations affecting that specific legal disagreement. Which the validity of an arbitration clause from the effectiveness as well as the ability to successfully draft agreements cannot be overemphasized. It is on these premises that the Nigerian Bar Association Abuja branch, ably led by the indefatigable chairperson and the person of Hawa Evelyn Shakarau, through the Committee on Continuing Legal Education, established pursuant to Section 10(4) of the Constitution of the Nigerian Bar Association, and saddled with the responsibility of organizing forums as this, and amongst other obligations, have put together this training to take on the focus, drafting effective and valid arbitration agreements. At this juncture, and with great pleasure, I have the singular honor to call on the chairperson of the Nigerian Bar Association Abuja branch, Dr. Evelyn Hawa Shakarau, to declare this training open. Please join me make welcome the chairperson. Ma, please, you have the whole.
Thank you very much for that intro, Chinelo. I want to very specially welcome Professor Emilia Oyema, a distinguished professor of law and lecturer at School of Oriental and African Studies, University of London. Incidentally, SOAS is my alma mater. I did my LLM at SOAS in 2006. So I'm so glad and so delighted that we have her today as our guest speaker at this webinar. Indeed, Professor Emilia Oyema is a world-acclaimed professor of law who is an authority in this area of arbitration. And so we count it a great privilege that we have her today as a guest speaker. And I'm sure many of us are going to learn and drink from the fountain of wisdom that the Lord has bestowed on her. I want to also use this opportunity to also welcome the chair of the Committee on Continuing Legal Education of the MBA Abuja branch, Professor Paul Idonije, Senior Advocate of Nigeria. Professor is retired, but he's not tired and continually engages in activities that seek to impact positively on our profession, and using his time, wealth of experience, and resources to impact on young lawyers that are coming up, including old ones like me, who are still greenhorns in this arbitration business. I also want to thank the co-chair in person of Professor Peter Akpe, Senior Advocate of Nigeria, and including other executives of the committee of the CLE. Thank you all for keeping faith with this committee. This is the 5th webinar that this committee is organizing, and I want to assure you that it has been a very rewarding exercise every time the webinar is held. I wouldn't want to take too much of your time. I want to yield the floor so that this all interesting webinar can go on. I thank you very much for the privilege to have all of you on board. Thank you very much.
Thank you, Madam Chair. Once more, welcome distinguished gentlemen of the INABA, ATABA, and to you participants in the world over. I am Chinelo Audrey Ofebun. I'm the Assistant Secretary of the MBA Abuja branch. I double as a moderator today, and I have the honor of co-moderating this training with the committee secretary in the person of Samuel Oguntiyi. That being said, please tag along, sit in, let us have your interventions on the platform, and then any of the moderators will do the needful. The rules of this engagement have been posted on the platform as I speak. Please do well to read and abide by the same. Thank you. Today, the focus will adequately be discussed by an erudite and torchbearer within and outside this jurisdiction. She's no other than an enthralling alpha female, a lady who blazes the trail and of many hats to it. A professor of international commercial law at the prestigious SOAS University of London, where she teaches international commercial arbitration and international investment law. She's qualified to practice law in Nigeria and a solicitor in England and Wales, a fellow of Chartered Institute of Arbitrators and an independent arbitrator. She convenes the SOAS Arbitration in Africa Conference Series and leads the SOAS Arbitration in Africa Binary Survey Research Project. Her research interests focuses on the development of international arbitration in Africa and the engagement of Africans in international arbitration. She's got experience as presiding, co- and arbitrator in international commercial arbitration. Gentlemen, with a clapping ovation, join me make welcome Emilia Oyema.
Can you hear me? Can you hear me clapping?
We can hear you.
Okay.
Yes, we're all clapping.
Okay, thank you very much.
Okay, well, it interests you to know that from inception through series 1 up to this 5th series, Professor Emilia has attended all 5 trainings. Isn't she awesome and a great support system?
Thank you.
We are indeed overwhelmed to have you speak to us today, and we appreciate you for your support always. Thank you. Well, distinguished members of the outer bar, the inner bar, and everyone logged in today, indeed, the focus for today is timely. Without further ado, Professor Emilia will delve right into the discourse. Thank you.
Thank you very much. Let me be sure can you hear me? Yep, okay. So thank you very much. Thank you for the kind words and the introduction. And I am very grateful for the opportunity to share with you something, a little bit on what I do here at SOAS and generally in my current career. And so today we're going to focus on what a valid arbitration agreement is. Arbitration agreement does not only need to be valid, but it also needs to be effective. so that you're sure that the reason why the parties chose to go to arbitration in the first place would be actualized. So what I propose to do is set out in the slide. It is to, let's just quickly go back, remind ourselves. I know that Chinelo is trying to remind us a little bit of what arbitration is, the relevance of the arbitration agreement. We'll look at some basic underpinning principles of arbitration, which you must keep in view, because that would help in your decision-making process. Would look at validity requirements, would look at whether the differences between ad hoc and institutional, and which you might want to choose when the opportunity comes. We'll then zero in on the arbitration agreement, look at the components. What must you have in your arbitration agreement? And then we will try to draft an arbitration agreement. So if you don't have a pen and paper, you need to get your laptop or your iPad or your phone, but you're going to draft. And I'm at liberty, I've been told, I can call on anybody to share their own draft. So you will get a set of facts. It's a very short set. It fits into one slide, and then you would try to draft yourself. And then we would look at the effects of a valid arbitration agreement. Then we would look at pathological clauses. And when we come to pathological clauses, we would do two exercises. So we're going to look at two clauses, one that Professor Idonije contributed and one that I adapted from a current instruction that I'm working on. And then we'll try to engage with that collectively because of time, to see whether those particular clauses can actually function. So the expectation is that just before we get to 4 o'clock, so about 30 seconds to 4 p.m., you should have a clear understanding of the function of arbitration agreements, really how fundamental they are, and all of the other learning outcomes. So the first thing to talk about is the consensual nature of arbitration. Now, we know that you also have mandatory arbitrations. So that is an arbitration that a particular statute requires. And usually you might have a tribunal. I'm sure some of you are thinking of the tax tribunal, arbitral tribunal in Nigeria. That is a type of mandatory form of arbitration. But if we go back to the Arbitration and Conciliation Act, it says that, and it is an act to provide a unified legal framework for the fair and efficient settlement of commercial disputes by arbitration. So the Nigerian law itself focuses on commercial arbitration. And Chinelo already reminded us that arbitration effectively, if you ask me to define it in one short sentence, it is private litigation. That is what it is. It is not mediation, where the parties are encouraged to come to a settlement, where the parties try to find a settlement. So there might be losers and winners, but at the end of the day, something that they can continue to live with. And so you would find, I know that there are mediators in the room, they talk about a win-win solution. Let's not debate whether you actually get a win-win solution, but that's what they tell us. But arbitration is not like that. In arbitration, there has to be a loser. There must be, somebody has to win and somebody has to lose. And that's why it is very similar to litigation. In arbitration, you have a neutral third party that makes a determination, makes a decision for the parties. It is not conciliation, where the third party would make suggestions to the parties that the parties may accept if they want. In arbitration, the arbitrator is a private judge. The arbitrator applies the law to a set of facts and arrives at a decision. And so we don't talk about settlement when in arbitration. but we talk of decision making in arbitration. And that is really, really important. So when we ask ourselves, so why does it have to be consensual? Why do we need the parties to say, yes, we want to go to arbitration? It's because the parties are, if you like, saying, listen, I have a constitutionally protected right to ventilate my dispute or my displeasure before a national court. But I am making an active, informed choice not to go before the courts and set up this private process wherein I would resolve my dispute. That is really key, because in that consensual nature, the party is opting out of their constitutional right to go before the courts to say, for this part of it, for this bit, we will go to private dispute resolution. An arbitrator will make that decision for us. Does that mean that we are ousting the jurisdiction of the courts? I think the Nigerian courts have determined this point. The fact that you signed up to an arbitration agreement does not oust the jurisdiction of the courts. Within the common law world, what it does is that it stays the jurisdiction of the court, if you like, because you get that determination. You can always go back to the court if you need assistance from the courts, and we'll come back to the role of the courts. And so what this means is that arbitration itself as a process is underpinned by agreement. And so Law 101, that for Professor Idonije, that might be like 50 years ago. But anyway, for some of us, that is almost like 30 years ago. You remember what agreement is. You need an offer, you need an acceptance. And for domestic arbitration, for those of us under the common law system, you need consideration. And remember that what consideration is benefit. You're getting a benefit or you're forfeiting a benefit. And so it is underpinned by contracts. We need to see, we need to be able to evidence that agreement, the offer and the acceptance of that offer. And all of that is it's evidenced in the arbitration agreement itself. Now, if arbitration is a contract, just like any other contract, it would have its own proper law. And so each jurisdiction has the way they define or how they find what the proper law of the arbitration agreement is. And we'll come back to the proper law when we look at the questions of validity. Any contract needs to be valid on the basis of a particular law. It's either it is international law, or it is domestic law, national law, or it's a convention, but there's a law that would determine whether the formal requirements, what is it that makes this a contract, are met, okay? And so those are parts of what will fall under the proper law of the arbitration agreement. And just again, like, how do you determine the law of a contract where the parties have not made an express choice? We know that we then begin to look at the law of the place that has the closest connection to that dispute or to that transaction. And so again, the same conflict of law rules would apply to determine the law that applies, the proper law of the arbitration agreement. In arbitration, there are certain basic principles, and these are really, really important because they underpin the whole of arbitration. The principal one is party autonomy. And what does party autonomy mean? It means the freedom of the parties to determine what they want. Is there anything that constrains party autonomy? Public policy and mandatory rules, that's all. And so when we go back to, we're not dealing with that, but in my course, we talk about the juridical theories of arbitration. And what you find is there's a spectrum. we have academics and jurisdictions that say, hang on, the state is important, and the state determines what happens within its territorial space. And those are the jurisdictional theories. And then you have different versions all the way to the free market people who say, why do you need the state? This is a private process. The parties are sophisticated. So why don't you let the parties do what they want? And anyway, most arbitrations would happen and the losing party will pay. The state won't even know that an arbitration has happened. So why should a state constrain or limit arbitration at all? And those are the delocalists or the transnationalists or the autonomous theories. Okay, so but party autonomy, all it means is that parties have the freedom to design the process, to determine what they want. Do you want 10 arbitrators? Do you want your seat in London? Do you want, do you want a particular law to apply? How do you want your arbitration? So that's what party autonomy is. The other thing is the autonomy of the arbitration agreement. And this is because the vast majority of arbitrations are included in a substantive contract. So if you pick up any contract these days and you go towards the end of that contract, you will generally see a dispute resolution clause. You will see either a jurisdictional clause, or you will see an arbitration clause. And sometimes people mix and conjoin everything, and then it becomes really difficult. You don't know which one they actually mean. But just that one sentence or one clause, we say is completely independent. It is separate from the underlying clauses, from the underlying contract. So if you have a contract that includes an arbitration clause, you actually have two contracts, one document. And then by the time you start thinking about it, and you have the law that governs the main contract, the question then becomes, is that the same law that will govern your arbitration agreement, or is it a different law that would govern your arbitration agreement? And so you look at most contracts up until sometime this year, most contracts will not. You would hardly find any contract where the arbitration clause includes a separate law and says the arbitration agreement will be governed by this law. But when we come to look at the components of what we should now be including in our arbitration agreement, it's become massively important, because P&ID is an example of what can happen if you leave it to chance where what the proper law of that arbitration is, or if it's not clear. The other thing is competence. Competence actually arose from a German word, and the difference in spelling is that the C becomes a K, and then with a Z at the end. And so competence just means the jurisdiction, the ability of the arbitrator to determine their own jurisdiction. Okay, and the idea behind competence is to ensure that those who have actually signed an arbitration agreement actually go on to effect that arbitration agreement by going through arbitration. Otherwise, all you need to say is that you allege fraud, or you say that the contract is invalid. And then you then have to go to a court to determine whether there is jurisdiction for the arbitrator to look at it at all. And so you can see that with the political changes and the policy changes, with more jurisdictions accepting arbitration and more jurisdictions becoming pro-arbitration, we're getting policies, we're getting rules, we're getting decisions that are more pro-arbitration than not. The fourth one is the autonomy of the tribunal, which flows from competence, so that the arbitral tribunal is master of its own process. So when you are appointed as the arbitrator, you are in charge of that arbitration. It is true that the powers and the authority of the arbitrator flows from the parties' arbitration agreement. But once the arbitrator has accepted, Florence, can you mute? Or Chinelo, can you mute people? Okay, thanks. So that once the arbitrator has accepted appointment, the arbitrator is in charge of that arbitration. If you look at any set of arbitration rules or arbitration laws, and you look at the procedural part, it would always tell you if the parties have not agreed. The parties can decide this, but if they have not agreed, the tribunal will decide that. Before the tribunal comes on stream, if it is institutional reference, usually in some institutions, not all, the institution would make some of those decisions. The last principle to bear in mind is the finality of the award. And so that will feed into the drafting of the arbitration agreement. This dispute, all disputes shall finally be resolved or finally be, well, usually resolved by arbitration, because there has to be an end to litigation. And so at some point, you have to stop fighting and a determination has to be made. And so the finality of the award basically is a means through which the award, the decision that has been made by the arbitrators is not open to a judge to change. And we have some Nigerian cases along those lines as well. So a judge cannot get an award and say, well, if it was me, I would decide this way. It's irrelevant. It wasn't you that the parties appointed to make that decision. And that is why generally in the literature, we say that there is no appeal. You cannot appeal an arbitration award, but you can challenge. And sometimes my students will say, so what's the difference if you can't appeal, but you can challenge? Because you can challenge on very limited grounds, unlike an appeal that is open-ended. So the last thing to say on that is the role of national courts. And the finality of the award leads us directly into the role of the national courts. So section 4.1 of the ACA clearly states that a court before which an action, which is the subject of an arbitration agreement, is brought, shall, which is a mandatory requirement, shall, if any party so requests. Why do we think? Because we'll come back, that's the same terminology used under Article 2.3 of the New York Convention. Because of consent, because it's a consensual process, you can't force anybody to go to arbitration. So if I have a dispute with Happiness, I'm just going to be looking at the names I can see, with Happiness Nnamdi, and we decide that Chinelo is going to be our arbitrator, but then I change my mind and I go before the High Court in Abuja or the Federal High Court, or any one of them, and file an application. And Happiness does not challenge the jurisdiction of the court. And Happiness does not say to the Abuja High Court, hang on, Emilia and I have an arbitration agreement. What that means is that Happiness and myself, we have repudiated the arbitration agreement. In other words, I made Happiness an offer to repudiate the arbitration agreement, and she accepted that offer. The court cannot, on its own volition, say to us, both of you step back, you have an arbitration agreement, go off to arbitration. The Nigerian law does not allow that. But the Ghanaian law, for example, allows the court to look at it independently, suo motu, and say, I can see an arbitration agreement, get out of my court. And so we need to be careful and be sure of what the law of that particular jurisdiction allows. And that's important. And so, well, I think I will stop there. We'll come back to section 4. And section 5 of the ACA 5.1 says, if any party to an arbitration agreement commences an action in any court with respect to any matter which is the subject of the arbitration agreement, any party to the arbitration agreement may, at any time after appearance and before delivering any pleadings or taking on any other steps in the proceedings, apply to the court to stay the proceedings. So generally what you would find in the common law world under the various statutes, arbitration law of the common law jurisdictions, is that the court will be asked to stay its jurisdiction. Well, that means you have an open file. You have a file number, it is open. It's just a stay. In the civil law tradition, the court is asked to reject jurisdiction. So you have no open file. There is no matter with your name on it. The court rejects jurisdiction. The other thing to bear in mind is that in some jurisdictions, and Nigeria is one of those, it says that, so we'll go back to section 4.1. It says, shall, if any party so request, not later than when submitting his first statement on the substance of the dispute, order stay of proceedings and refer the parties to arbitration. In the vast majority of jurisdictions, the wording in the statute stops at stay proceedings. Because again, if you think about it, and that's something we need to think about with the revision of the law, if we include and, it says here, currently it says, and refer the parties to arbitration. What if the parties do not want to arbitrate anymore? But if the court now says, go to arbitration, is that a court order that if one of them does not obey, they will be in contempt? So that's something that we need to think about. Okay, so what's the functions of the arbitration agreement? So as you can see by now, it evidences the consent of the parties to arbitrate their dispute. In our jurisdiction here, the English Arbitration Act recognizes that you can have contracts and agreements that are oral. And so the arbitration agreement is a matter of evidence. I think sometimes we forget that. It evidences the terms of that agreement. And that's why it's better that it is in writing, so that we're not going to start arguing on what we agreed. But the English Arbitration Act, as a matter of evidence, says that where in the statement of claim, a party alleges that there is an arbitration agreement and the other party does not dispute that, that allegation becomes the arbitration agreement. It's a parole evidence rule. And so it's clear we can understand that. But it's really important that the arbitration agreement, that consent. So be thinking of the things I'm emphasizing, because that's what you will use when you're drafting your agreement. You want to be sure that you can see the concept, that there is clear evidence that the parties want to go to arbitration. So the consent of the parties to arbitrate their dispute. The second thing is go to arbitration over what? And so we talk about covered disputes. And you want to draw it if it's a clause. So if it is a pre-dispute agreement, you want to draw the agreement as widely as possible, because you don't know, it's in the future. You don't know whether you're the one that want to go to arbitration. You don't know what the arbitration will be about. And that's why it is almost any and all disputes, okay? Which is different from a submission agreement, because in a post-dispute agreement, which is a submission agreement, you know what the dispute is. So you can draft a completely bespoke arbitration agreement. The arbitration agreement is the foundation of the jurisdiction of the tribunal. That is where the powers of the tribunal arises from and the jurisdiction of the tribunal. It establishes a contractual obligation of the parties to arbitrate. And that is why the courts will stay proceedings. And some courts, like the Nigerian law, the court will say, go to arbitration. And that is why in this jurisdiction, if you in contravention of your arbitration agreement, you commence litigation, you would get damages order made against you because you have breached the terms of your arbitration agreement. And maybe why we don't have here that injunction to the courts to refer the parties to arbitration, maybe it's a question of specific performance, which is an equitable remedy and not a legal remedy. And so I don't know the answer to that, but something for you to think about. Lou, Mistelis, and Crow note that arbitration agreements therefore have both a contractual and a jurisdictional character. And that goes back, if we think about the theories, the underpinning theories, there is a jurisdictional element, and then there is the contractual element. And so it's how much the both characteristics fuse. And so we do have, we also have an hybrid theory that looks at that. So Nigeria is a member of the New York Convention, which I think now has about 168 member states. If you're not familiar with the New York Convention, or if you are familiar and all you hear about is awards, 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 you'll be forgiven for thinking that the New York Convention only deals with enforcement and challenge of arbitral awards. The New York Convention deals with the enforcement of arbitration agreements and arbitral awards. And Article 2.1 of the New York Convention talks about the obligation on that contracting member states have taken on. So Article 2.1 says each contracting state shall, and it is a mandatory requirement, shall recognize an agreement in writing. And so the New York Convention is it provides the most stringent regulations, which means that a national law might not necessarily require that the agreement be in writing. So the 2010 amendment of the Uncitral Model Law, option 2, does not say anything about the agreement being in writing or not. And so via Article 7 of the New York Convention, you can enforce recognize an arbitration agreement that is not in writing under the New York Convention, in spite of Article 2.1. So Article 2.1 says each contracting state shall recognize an agreement in writing under which the parties undertake, so again, that consent to submit to arbitration all or any differences which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not, concerning a subject matter capable of Obina, can you mute yourself? Obina,
I beg your pardon.
I'm so sorry. I'm so sorry.
Yeah. Let me just mute everyone and then you'll mute yourself. You're a co-host, so you can unmute yourself.
Great, thank you. Can you hear me? Yeah, okay. So whether contractual or not, concerning the subject matter capable of settlement.
His father was the
Miriam Aruna, please mute yourself.
Let me look it. guess she's not able to unmute herself anymore.
Okay. They promise to recognize an arbitration agreement. Now, I've said that by virtue of Article 7 of the New York Convention, you can't bring an arbitration agreement that is not in writing, so an oral agreement. But it's always better to have it in writing. Remember that why you opted for arbitration in the first place is you do not want to start the resolution of your dispute before the courts. So you don't want to, first of all, go to the courts for the courts to determine whether there is an arbitration agreement before you even start. And that's the reason why it's important that the arbitration agreement is properly drafted anyway. Okay. And so we want to see the promise. So that's the undertake means to promise. We want to see the promise of the parties to submit their dispute to arbitration. And we want to be sure. So you look at an arbitration agreement, what you're looking at is, can I see where the parties have promised to go to arbitration? If you can find consent, the next thing you're looking for is go to arbitration over what? Because sometimes it's not everything that the parties want to go to arbitration over. So that you want to be sure that the dispute before you as a tribunal is a covered dispute. That means it falls under the arbitration agreement. Okay? So the clause or the submission agreement, then you want to be sure that there is a defined legal relationship. So Obinna and myself, for example, can't meet today and say hello and sign an arbitration agreement. It makes no sense. It is maybe we have a transaction, we're trying to enter into a deal, a contractual, a legal relationship before, so that if a dispute arises out of that, then we can go to arbitration. The other caveat is, does the state allow you to go to arbitration? And so we go back to those theoretical underpinnings on, is the state still relevant or the state is not relevant? And so is it arbitrable? Is the subject matter one that you can go to arbitration over? So there is the current, I don't know if it's been settled now, disputes going on in Nigeria, whether contractual aspects of tax disputes can be arbitrated or not. And so those sorts of questions can, or where we have in family law, in the vast majority of jurisdictions, a decree nisi cannot be arbitrated. It's something that the courts would need to determine. But can you arbitrate the question of determining the properties and the assets of the parties? In this jurisdiction, yes, you can do that. Okay. So the next, can I still move my slide? Yep. Okay. So the Arbitration and Conciliation Act defines for us what a valid arbitration, a formally valid arbitration agreement is. So when Nigerian law applies and governs that arbitration, the arbitration agreement must be in writing. That is really, really important. Then the other bits of Section 1 just expands on what writing means. The additional writing requirement or of what writing means will be useful if we reform our Arbitration and Conciliation Act. So we adopt the revised model law, and we will look at that to see Remember, again, you're using the in writing as evidence. You want something that would evidence that the parties actually agreed to go to arbitration. So it can be by reference, it can be contained in an arbitration agreement and all of that. Okay, so if you look at option 1, that of the model law, Article 7, it says an arbitration agreement is in writing if its content is recorded in any form. And that is important. So for those of you, I know that in Nigeria, a lot of people conduct business using WhatsApp. And so can you record, is the content in a recorded format in such that you can reproduce it? You don't have paper, but it can be reproduced in paper format if you need. Okay, and so if you're dealing with Bitcoins, you're dealing with all of those sorts of documentation with electronic communication and all of that. How are you going to evidence that? The key thing, what you're thinking about is, how do we evidence that? Would an email where I had sent to Obina an email to say, if a dispute arises, we would go to arbitration before the Lagos Court of Arbitration or whichever one, would that satisfy for evidential purposes the in writing requirement? So that's something to think about. And so the key thing is, where you have a video recording and somebody is recording, Obina, and we're just chatting and we say, yes, we would want to go to arbitration, but we've made a video recording of it. Would that be admitted in evidence? So that agreement was made orally, but we have a video recording of it. Okay, so those are the sorts of things you want to think about. And those are questions of formal validity. So remember that it is a contract, is an agreement, it's a contract. So you want to evidence that agreement. What do you want to show in evidence? You want to show that there was a clear intention to submit the dispute to arbitration. Now, if it's an arbitration clause, most likely you would already have a signature. Now, remember that this is a question that will be determined by the proper law of that arbitration agreement. And so does a signature a mandatory requirement for a valid arbitration? If it is, then there has to be signature somewhere. If it isn't, then signature is not necessary. The other thing to think about is the capacity of the parties. The parties, do they have capacity to conclude a contract? So I'm doing an arbitration where both sides are non-governmental organizations, and it's an international arbitration. And do they have capacity to conclude a contract? Quite a number of Nigerian cases that on question of capacity goes to whether a company that operates in Nigeria but is not registered under CAMA can, I think Prof, has capacity to conclude an arbitration agreement. And so I know that Prof has a view on that as well. But capacity is really, really important because it is a contract. So if the law and the law that would determine the point of capacity will be the proper law of the party. So if it's a company where the company is registered or where its head office is, if it's an individual, the proper law of that individual. Then substantive validity, the general requirements for a contract. So we've talked about those. We've talked about scope of the covered disputes. So Article 4.1, Article 5.1a of the New York Convention talks about the law that would govern that question. And so it talks about the parties to the agreement, if they were under some incapacity or the said agreement is not valid under the law in which the parties have subjected it. So if they've made a choice of law, or failing which the parties have, or failing any indication thereon under the law of the country where the award was made. Okay, so you would notice that the most complicating thing about international arbitration is that you can have 6, 7 different laws interacting at the same time. So you have to be able to determine what law governs a particular question. Okay, so what is ad hoc arbitration? What is institutional arbitration? So the survey we did for 2020, we looked at African arbitral centers to identify the top 5. And none of the centers in Nigeria was part of the top 5. And it's not because in Nigeria there isn't lots of arbitrations happening, but for some strange reason, Nigerians are wedded to the idea of ad hoc arbitration. And so ad hoc arbitration is an arbitration that doesn't happen under the rules of any particular institution. So we all know what, the arbitral institutions that we have. And my personal opinion is that Nigeria needs to move in the direction of institutional arbitration, because it's easier to get data to know exactly what is going on and to have some degree of oversight with institutional arbitration, unlike ad hoc arbitration. And some of the stories coming out of Nigerian ad hoc arbitration scene, it's a little bit concerning. And so that oversight is really important. Section 53 of the ACA refers to parties can refer to or adopt the rules attached to the ACA or the UNCITRAL rules or any set of rules that they want for ad hoc arbitration. The key thing I'm going to say about ad hoc arbitration is that in ad hoc arbitration, the law of the seat of arbitration becomes really, really important, because they act as gap fillers. They help the parties. Unlike in institutional arbitration, where the rules of the arbitration institution form an extension of your arbitration agreement, they effectively are linked back to your arbitration agreement. So I'm going to pause so I can catch my breath, and I'm going to ask a question. And just for your view, I would like to hear people's views on which they prefer, ad hoc or institutional arbitration, and why. Samuel, or can I ask one of the moderators to please check if anybody raises their hands? I can only see my slides. If nobody is raising their hands, then I'm quite happy to call on people.
Okay, so someone's hand is up or has been up.
Yeah. Do they want to answer? Which do they prefer? You can put it in the chat as well if you prefer. So which do they prefer and why? Professor Idonije, which one do you prefer and why?
This to them, for some purpose, I prefer ad hoc. For some other purposes, I prefer institutional. You cannot really appreciate the virtue of using a non-arbitral institution, because you are sure that they are quite experienced in the administration of your arbitrator, and you need not appoint another appointing authority. Whereas when you are into ad hoc arbitration, because it's not managed or administered by an institution, you will need to have an appointing authority. Like I said, they have their pros and cons, but for our purpose in Nigeria, we are getting close. We have the regional center in Lagos. We have the Lagos Court of Arbitration. We have ICAMA. We have JICAM. I think we are getting close, because some of them have their own rules. So as soon as they are being patronized, we'll move towards having institutional arbitration in Nigeria. Thank you, but I prefer to leave it to others to contribute. Thank you.
Thank you very much, Prof. Does anybody else want to?
Yeah, I would like to, I don't know. I mean, it appears to me, I have just written and passed the exams a couple of months back to be an associate of the Chartered Institute of Arbitrators. So I haven't really practiced any arbitration yet, but it looks as if ad hoc, the ad hoc arbitration might be less expensive than institutional arbitration. I may be wrong, but that's the way I see it. I don't know. So correct me if I'm wrong.
Okay, great. Thank you very much, Awa. You're not wrong, but it all depends. And I'm going to explain it all depends. So we have in the chat, we have Peter Okaku, who says, I prefer institutional arbitration because it's more seamless in terms of management of the arbitral process, which is absolutely correct. And that's a huge plus. And then Okechukwu says, institutional arbitration is in the developmental stage. We should therefore strengthen it to be part of global best practice. And that is by ensuring you use it. So I'm adding that now. Olajide says, ad hoc or institutional, I guess it depends. I'd prefer institutional for big corporate disputes and ad hoc for small individual disputes. It would be nice to know why. Onyekachi says, I prefer institutional. The logistics will be taken care of by the rules of the institution and the fees too. Ngozi Princewell says, cost is a big implication in institutional arbitration. Okay, and so that comes back to Hawa's point on cost. I just did a paper actually where I said, and it's going to come out in the IBA journal. And one of the things I said in that paper is that the cheapest dispute resolution process in quite a number of African countries is litigation. It is, you pay court fees and all of that. It is litigation. Arbitration is expensive.
We missed you a bit, Prof. I think
sorry.
like you went off a bit.
Okay, can you hear me now?
Yes, we can hear you now.
Okay, so in that piece, I said that the cheapest one, or the cheaper of the two, arbitration or litigation, is litigation in most African countries. It's not the same in the West, where litigation is actually can be quite expensive. But what you get is in institutional arbitration in Africa, in different African countries, just looking at arbitrators' fees, not the legal costs. Looking at arbitrators' fees, it is very, very low. Very low. Very, very low. Now, ad hoc, you fix your own fees. You agree with the parties what they will pay you. You want a percentage, that is fine. So you can charge as much as, or even more than you would earn if you were sitting under the ICC rules. But institutional arbitration in Africa, different African centers, you will not get a tenth of what you would earn, or maybe 20% of what you would earn if you were sitting over the same value dispute before the ICC and co. And so cost-wise, as it relates to the fees of the arbitrators, institutional arbitration is really cheap on the continent. And of course, I challenge that, because I think that wherever you sit as arbitrator in the world, it should be equal pay for equal work. But because, and the argument I make is that because institutional arbitration is still relatively new, it's quite modern on the continent, institutions cannot really afford to charge as much as, places like the ICC that have been around for over 100 years. And so we understand that. So as it relates to cost, maybe the jury is still out, but institutional arbitration most likely will be cheaper. But again, we need empirical evidence to be able to determine when we're looking at exact figures. Okay, so we'll carry on. Okay, so what are the components of the arbitration agreement, or what must you include in your arbitration agreement? The names of the parties must be right. It has to be correct. So if it is Emilia Onyema is not Emilia Onyama. It is not. There is no A before my M in my last name. If you put an A before the M, that's not me. And so the worst thing that can happen to a party is where you commence an arbitration before the wrong party, because the correct party just needs to keep quiet. Statute of limitation is running, and it's not their fault. So it's massively important that you get the names right. You sue the correct party. And a lot of problems in that field is where you have mergers and acquisition or insolvency cases where an administrator has taken over the company's activities. There has to be an underlying transaction. We've discussed that already. You need clarity. The wording has to clearly show the submission to arbitration, the scope of that submission, so the covered disputes. There has to be that element of finality. It's good that you make clear what the language is. One of my colleagues here in SOAS a few years back had an arbitration in the Middle East, where the parties, the contracts were in Arabic, there was some in French, there was some in English. They didn't say what language will govern their transaction. When the dispute happened, the first thing they did was to go to court for the court to tell them which language will govern that particular arbitration. You don't want to do that. Remember, you want to avoid those things. SIT is hugely important. And it's not just important because you have a domestic arbitration, P&ID, and then you say venue, London. Venue London means nothing. It's not enough to say venue London. You have to be clear what the legal sit is, because you can have your arbitration anywhere, especially with COVID-19. You can have lots of all the ones I'm doing currently are online. You can do that online, but you have to have a seat that localizes your arbitration to a particular jurisdiction. That is really important, because that's the jurisdiction that would provide legal support to your arbitration. It's important to determine the number of arbitrators. And here you need to be very careful, because the more arbitrators you have, again, depending on where your arbitration is taking place. So I've sat under a set of institutional rules on the continent, where if I was sitting as a sole arbitrator, I would earn the same. If there were 3 arbitrators, the 3 of us would share that same amount of money. So it wouldn't make much of a difference. Whereas in some other, under some other rules, you pay more depending on the number of arbitrators. So small value disputes, and quite a number of institutions are making it really clear that small value disputes, you get a sole arbitrator because there's that need to keep the cost down. How will your arbitrators be appointed? Do you need an appointing authority? Prof already alluded to that. Who would that be? So an appointing authority, for example, can be in SOAS, our vice chancellor, that we don't call a vice chancellor, we call the office of the director of SOAS. So that can be the appointing authority. You can make anybody your appointing authority, But the danger with making a human being, an individual, you're appointing authority, is that they may be conflicted and they may not be able to act when the need arises. And so usually people would nominate an office. So whoever is occupying that office would take on that role. I'm very much in favor of, on the continent, of appointing authorities that reside in country, because they would know the arbitrators that function in that space. I don't understand why any Nigerian arbitration would be nominating the Secretary General of the PCA, Permanent Court of Arbitration, or UNCITRAL as your appointing authority. I can't understand it, but that's what we have. Anyway, the law, and then the most critical thing now with the Halliburton decision from this jurisdiction is that you now need to include the law that will govern the arbitration agreement. You can't leave it to chance. You have to include the law that governs the arbitration agreement. Remember that once the parties have made a choice, that is always the first bar. And every single jurisdiction is a contractual provision, would abide by that. If you then leave it to the court to determine what the choice would be, you might be a little bit surprised. And P&ID is an example of that. So I'm going to ask, is there anything else we think should be part of the arbitration agreement? 30 seconds. Anybody? Is there anything else that we think we should be including? Okay, thank you. So we'll move on. So how do you negotiate the arbitration agreement? I think that the time is gone past for people. So before the 1990s, a lot of universities didn't have an arbitration module. People were not going to study arbitration in the university. The most you would find is that it might form part of a conflicts of law module or course. And so, but now we have, every single university does arbitration, has a module or a course on arbitration. I have on the undergraduate, in our department here, we have for our final year undergraduate students. And so there is need for expertise, people who truly understand the various things we've been talking about. A couple of sessions back, Professor Donije had given a webinar on boilerplate clauses. And so should we use boilerplate clauses? I don't know. My view is that might be the starting point, but no copying and pasting, because your clients might want something different. It's usually referred to as the midnight clause, which is why you find it somewhere down below. Remember, for me, the way I look at the arbitration agreement is that it's the responsibility of the lawyers, because the parties are not particularly hoping that they will have a dispute. They're looking at the benefits of their transaction, how much they will make, and all of that. They're not thinking of a dispute. The way I describe it to my students, and I have to have my eye on the clock, is that it's like a guy or these days, man or woman, it doesn't really matter now. You meet somebody and you fall in love, and they just keep staring at each other. They're forever smiling. They're happy. At that point in time, if you ever say to them that there might be a fight, you'll be the enemy. They would not believe you. And so if you attend a wedding, you can see that everybody is happy, well-dressed, and all of that. If you go to a divorce proceedings, you'll be shocked that, is it still the same people that I saw a few years back happy? It's the same thing in arbitration. So it's for the lawyers whose feet should be on the ground to think about the type of dispute resolution clause that they should include. You can use the model clauses that institutions have adopted and have included, and you can adapt it depending on what you want. It is usually not very advisable to do a bespoke, to start afresh. But some lawyers prefer to do that because it's more billable hours. But you want to be sure you capture at least the essential provisions. Okay, so it's time for me to keep quiet a little bit. And this, you need to draft an arbitration clause. You're representing the company. So it's a transaction for the supply of equipment. You have a Nigerian company, so it's registered under CAMA. The company has offices in Lagos and Port Harcourt. And the Lagos state government, so they're supplying the equipment to the Lagos state government. Your job is to draft the arbitration clause that will form part of that contract. The value of the contract is 700 million naira. The CEO of the company is an English person. And along with two other British citizens, one who is a Nigerian British person, they own 51% of the shares of the company. The remaining shares are traded on the Nigerian Stock Exchange, owned by various people. The contract is for 12 months, from the date it is signed, but we have governorship elections in Lagos State in the next 5 months. And the current governor will not be running for re-election. So assuming that is APC, as the Lagosians are, that is APC that will win, but the governor is not running. So a new governor will come in. So you have 2 minutes to attempt to scribble something. And I'm going to ask people to speak to what they've written. So 2 minutes while I catch my breath. Okay. Is anybody happy to share to say what their draft says? It's just read out your draft clause. Anybody? Okay, so should I start calling names? Oh, we have.
I think Chuku's hand is.
Yeah, Chuku, please go ahead. I think I can unmute him. Oops.
Okay, Prof.
Yeah.
Yes, my draft may be long, but permit me to read it out.
Okay, short.
Any dispute or claim arising out of or relating to this contract agreement, including any question regarding to its existence, interpretation, validity, breach, or termination thereof, shall be referred to and settled by arbitration. The sole arbitrator shall be appointed by ICAMA, Abuja, and shall be conducted in accordance with the Arbitration and Conciliation Act, laws of the Federation of Nigeria, 2004. The seat of arbitration shall be Abuja, Nigeria. Thank you.
Thank you very, very much. Okay, I have one concern.
Yes, ma'am.
Come back at something for you to be thinking about. We have a few hands. Why a sole arbitrator for 700 million naira? I just wanted like £1 million, so I converted. So 700. Okay, Peace. Thank you. Peace, do you want to unmute Peace so that we can hear?
Okay. Good afternoon.
Good afternoon.
Any dispute, controversy, or claim arising out of or in connection to this agreement between the parties, including any question regarding its breach, validity, or termination, shall be reserved by an arbitration under the Lagos Court of Arbitration rules, which rules shall be deemed to be incorporated by reference. The number of arbitrators shall be 3. We shall be appointed by the Lagos Court of Arbitration. The seat of arbitration shall be Lagos, Nigeria. And the contract or the governing law for the transaction shall be the Arbitration and Conciliation Act, 1998. The language of the arbitration shall be English. Thank you, that's all.
Okay, thank you. Can I ask you, did you adapt the model clause that the LCA produced? Did you look at the LCA rules? No? Okay. Okay. It's always helpful when you want to appoint or use an institution to look at the rules, to know what because just like your clause says, it pulls in, it includes every term in the rule. Thank you very, very much. Is there anybody else that wants to, well, yeah. Anybody else? I don't, is there any other hand? Okay, great. Thank you very, very much for sharing your drafts with us. Okay. So what would be the effect of a valid and effective arbitration agreement? So the Supreme Court says that the court ought to give due regard to the voluntary contract of the parties by enforcing the arbitration clause as agreed by them. I think the operative words will be due regard. In other words, a deference, and that is what arbitration supportive jurisdictions do. Now, that a jurisdiction is arbitration friendly does not mean that anything the arbitrators say they would accept. No, that's not what it means. But it means that the courts would give deference. They will consider what the arbitrators have said and done. They will comply with their own law. So our law is clear. There's an arbitration agreement, stay your jurisdiction and send the parties off to arbitration. That is the law. Our judges need to abide by that law. But at the same time, they then need to give due regard, okay, to the contract of the parties. If it is a contract, as we have said, then a party who goes to court is in breach of that contract. And so what the courts want to do is to hold the parties to their agreement. Article 2.3 of the New York Convention says that the court of a contracting state, when seized of an action in a matter in respect of which the parties have made an arbitration agreement, using my own words, shall, mandatory, at the request of one of the parties, we've explained that, we saw that under the ACA, refer the parties to arbitration unless the court finds that the said agreement is null and void. And the way we define null and void, it's a contract. So what makes a contract null and void? Which means it was void ab initio. There was no contract to start with. And if anybody hasn't read Fiona Trust, it will be useful to, and Privalov. It's an old, it's not too old, it's a 19-something case, where Lord Hoffman defined separability, and it is on separability. And so, but he also talks about the exceptions to the separability principle. And so null and void, there was no contract in the first place. So it has to be something that is really, really a fundamentally vitiating factor. Inoperative is that there was an arbitration agreement, but you cannot operate it. It cannot come to pass. So for example, if you have a named arbitrator and the named arbitrator does not wish to accept appointment, or you have an institution that is no longer in existence. And so the other thing is that it's incapable incapable of being performed, so that the arbitration agreement cannot effectively be set in motion. And that's, that's where you have the named arbitrator not wanting to act. And then the other one is it's inoperative, where the arbitration agreement has now lost its effectiveness. So they're quite similar. So where, for example, the arbitration agreement has been revoked, so it's no longer in existence, or where because of lapse of time that was not renewed, the arbitrator lost their mandate. Okay, and we've talked about section 4.1 of the ACA. Okay. So there are two types of injunctions: where a party commences an action before the courts in disregard of an arbitration agreement. Remember that the law says that the other party can, before taking steps in the proceedings, can assert the arbitration agreement. The way to do that is to apply for an anti-suit, so to stop the litigation injunction. The anti-arbitration injunction is the other way around. So anti-suit injunction, you apply before the courts. Anti-arbitration injunction, you apply before the tribunal, where the tribunal is requested to stay its proceedings so that a particular bit of the dispute will be taken to litigation before the courts. Okay. So this we will do together. And this, I think that's the last bit. So what we want to look at are some pathological clauses. So let me see, exercise 1, yeah. So this is a clause that I'm currently working on. And it's in a contract that I am advising on. And so the heading of this part of the contract just says disputes and arbitration. That's the only place where arbitration is. I've changed the name of the country to Nigeria. So it says any dispute arising out of or in connection with this contract, including any question regarding it's exciting. This is exactly what it says. So clearly there's a typo with the exciting. Validity or termination shall be referred to and finally resolved by Nigerian Chamber of Commerce. Do we have a Nigerian Chamber of Commerce? And that's all it says. Anybody? Does anybody want to? So let's do the exercise. Is there consent to go to arbitration? Can we see the parties' intention to submit their dispute to arbitration? Anybody? Yes, Owen, please.
All right, good evening.
Good evening.
Okay, so it makes no reference to arbitration, but it just says it shall be referred to and finally resolved by the Nigerian Chamber of Commerce. Obviously, the Nigerian Chamber of Commerce is not an arbitral institution, and there's no express relation, there's no express reference to arbitration. It just says Nigerian Chamber of Commerce. Whether it exists or not, we don't know, because the Nigerian Chamber of Commerce could actually have a department that has to do with that are actually concerned with arbitration, but it makes no reference to that in the clause or in the agreement.
Okay, great. Thank you. Does anybody else want to say something in favor of arbitration? So the problem with this clause is that it would depend. And so the way I'm viewing it, my current thinking, I have not crystallized, but the way my advice most likely would go is that that particular country, they have a chamber of commerce that has an arbitration institution that is attached to the chamber of commerce. And so the advice will be two-pronged. The first one is commence arbitration with that center. And the reason is simply because it is for the center to first of all look at it and say, well, we can see an arbitration agreement that refers to us. Remember that a center can say no to a claim. They can say, we can't, this arbitration agreement does not refer to us. So you can try, okay? So we can say, so the advice, the way we're thinking, the team is thinking is, we would ask them to go to that center and commence arbitration. If the center accepts the filing, they would then appoint an arbitrator. It will be for the arbitrator to then determine it as a question of jurisdiction if the other party shows up. If the other party does not show up, I think the arbitrator should still ask for submissions on whether they have jurisdiction or not. And then that way, the arbitrator will make a determination on their jurisdiction. There is some strategy here because we're suspecting that the other party would not show up. If the other party does not show up and they're given adequate notices and all of that, and an award is made at the end of the day, it becomes a question that will fall under the New York Convention because that state is also a New York Convention state. The second level of the advice is they should go to the court where that Chamber of Commerce, where the arbitration center of the Chamber of Commerce is located, and ask the court to determine whether this is a valid arbitration agreement. If the court determines that, yes, it is a valid arbitration agreement and that they can go to that chamber, then that's it. That sorts that matter completely. Whether they show up or they do not show up, you get an award, you can enforce it. Okay? But the key thing is, I completely agree with what you said. My first impression was the only place where arbitration is mentioned is the title, the section heading. And this is a huge problem. Clearly, they were copying and pasting, but they did not finish copying and pasting. Whoever drafted this was in a hurry. It's exciting validity. You can see that it was hurriedly done. Does anybody else have any ideas? Does anybody else want to say anything on this clause so we can quickly move to the second one?
Yes, Emilia, can I come in?
Yes, please, Prof.
Yes, I find the clause very interesting.
Okay.
The ICC is International Chamber of Commerce, and it has its own court of arbitration. in the same vein, the Nigeria Chamber of Commerce, I think, has an ADRO section or so. So it could be that what they have in mind is, like you said earlier, if the matter goes to the Chamber of Commerce, it will be referred to their section that this would be here to handle. It's a possibility. I don't know. But I think that they may be influenced by ICC, which is, but usually the rules of arbitration of the ICC, not just ICC. So,
Prof, you remember that in Nigeria, there's the Abuja Chamber of Commerce. They have attached to them. Lagos has.
They do. Yeah.
So that's the hedging. It's all you're looking for. Who would accept it? It all.
Yeah.
But it's not a good clause at
all.
No. We have two hands raised. Please go ahead. And we have Okechukwu and Dr. Agada. Agada, we've heard from Okechukwu. Should we hear from Agada first? Then we'll come back to Okechukwu, please. Is that okay, Okechukwu? Agada, please. We can't hear you. You're still muted. Okay, while Agada is unmuting.
Doctor, please unmute yourself. I've sent you.
Okay, Chuku, do you want to go ahead while Agada is
okay, I think Chuku has said.
Okay, Prof, looking at that clause, disputes and arbitration. And my understanding is that the Chamber of Commerce may not necessarily be utilizing arbitration mechanism. They might also have other ADR processes. And therefore, it may not necessarily result in arbitration. It could be settlement by mediation or some other way. So that's why they say disputes and arbitration, meaning that there are disputes and there is arbitration process. So it is worse for us to assume that arbitration is the intention of the parties. They probably have other ADR mechanisms also behind the pathological agreement. Thank you, ma'am.
Okay, thank you very, very much. That's an important observation. Even though you yourself gave the answer, which is if they had said disputes, mediation, and arbitration, then it opens up. But I can easily use your own argument to counter what you've said because they just said disputes and arbitration. But that is absolutely fine. Remember that it's the party that wants to commence this arbitration. Maybe they might end up wanting to just do mediation. Then it depends on what they argue before the center. But you're absolutely, I think that's very helpful. Agada, are you unmuted? Okay, so I'm going.
Okay, sorry. Can I come in again, Amelia?
Okay, Prof.
I think that these are some of the takeaways from this training program, because in practice.
Prof, pause. Let's hear from Agada, then you come back. Agada, we can hear him now. So,
Professor Amelia, you want to put me in trouble with my...
It's fine. It is. I'm far away, so it's okay. Go on.
Okay, thank you. Okay, I just wanted to provide information that the Chamber of Commerce, the Nigerian Chamber of Commerce now has a dispute resolution center. So that's the NASIMA. Its dispute resolution center is now housed by the Abuja Chamber of Commerce Dispute Resolution Center. So if there was a clause that said that it will be resolved by Nigerian Chamber of Commerce, then of course the structure of the Dispute Resolution Center can be activated to deal with that. As to whether it will be mediation, arbitration, that's a different matter altogether. I just wanted to provide that information. Thank you, ma'am.
Great, thank you so very much. Professor Idonije, the floor is yours. We can't hear you, you're muted.
Okay, thank you, Amelia. I was saying that this is one of the takeaways from this training program, because in practice, we find clauses like this. Parties cannot be running away from the court. Then we, the draftsmen or the arbitrators, are chasing them back to the court. A clause like this may result into litigation, and the court will decide whether it's operative or inoperative, whether it can be severed, or whether they can rewrite the contract for the parties. What am I trying to say? That we, as lawyers, as arbitrators, we should ensure that our job is comprehensive and not expose our drafts to the courts to interpret. Thank you very much.
Thank you so very, very much, Prof. That's very, very helpful. So we will now do the second clause, which Professor Idonije contributed, and I'm sure you're all very familiar with this clause. So we'll take 30 seconds, read it, and then we'll take comments. And preferably would hear from people we haven't already heard from. Okay. Before I take Esosa, whose hand is raised, I quickly went through the chat and saw that Mirabel, who is one of the senior lawyers here in the UK, she says that we should remember that headings are included in an agreement, usually for ease of reference, and do not affect the interpretation or construction of the agreement. And that in her view, it is unlikely that a mere technicality and a typo, you remember we saw the typo, would defeat the intentions of the parties, which appears to be in favor of arbitration or some other means of ADR. So we have some seriously supportive arbitration people in the room. So again, we need to wait and see, but that's a helpful just a reminder for us. So Esosa, you want to kick us off on this? Yes, please. What do you think? Esosa, we can't hear you. We still can't. We can't hear you. Faintly, but go on.
So what I wanted to say was there's no much.
Okay. So your major concern is President of the Chartered Institute of Arbitrators, London, Nigeria chapter, that there isn't such. Okay, great. Okay, Rashidi. Moderator, please, can you unmute Rashidi?
Okay. Can you hear me now, please?
Yes, we can, please.
Okay. I've gone through thank you. I've gone through the draft of Prof. I just want to ask one or two questions, and if Prof could enlighten me the more. I observed that running through that draft, I could see the use of may. If you go and that there is how do I put it? There is that several usage of the word may. So I want to ask, does it make any effect instead of using may for us to use the word shall? Bear in mind how the two words are interpreted judicially in Nigeria, at least. So I want to know whether that has any effect on such a clause and what effect it would have. Because if I were to interpret the way it is, I could as well say this does not, strictly speaking, mandate parties to go to arbitration in cases of dispute as envisaged. They may choose not to.
Okay.
So that is where.
Okay, so the fact that is permissive and not mandatory. Okay, and we then have one. Who again? Who has not spoken? Adeyinka. Please, can we unmute Adeyinka and then Onyekachi, and then that's it. Adeyinka.
Yes, good afternoon, Prof.
Yes.
What really catches my attention is the fact that the venue is London. And I'm wondering if the law governing it is the laws of, are the laws of the Federal Republic of Nigeria.
Mm-hmm.
Why should the venue be London? And I would also think that it's important to state that the language would be English.
Okay. Okay.
Thank you.
If that's what the parties want, it might be Yoruba or French. Okay, great. Onyekachi, please.
Thank you, ma'am. I can observe that there is that prerequisite to arbitration. It says any dispute which cannot be resolved between the parties by mutual agreement after 30 days. So this necessarily means that before the parties can even want to consider arbitration, there has to be a proof that they have tried to settle and they couldn't settle within that 30 days period before they can move forward to request for arbitration. Otherwise, that condition is going to kind of stop them from going forward to have the dispute arbitrated upon. Thank you, ma'am.
Thank you very much. I think those are all legitimate concerns that people have raised. The fact that it is there isn't a mandatory you have to go to arbitration. The fact that it leaves it open to interpretation, that you have to try to resolve the dispute when it has arisen. And how do you then note that you have actually tried? What if the other party is just messing around and does not show any major concern or seriousness in trying? The mays are concerning, and that's been raised. What else? Shall have the right to appoint a third arbitrator. Do we have concerns as the fact that the third arbitrator would only serve as an umpire and not as a presiding arbitrator? So basically, where you have an umpire is when the two party appointed arbitrators cannot agree, that the umpire then steps in. You've already raised the Institute of Arbitrators London point, and there's court judgment in Nigeria on that. The English courts in 1984 or thereabouts gave a decision where they said where the parties have something similar, and they subjected the arbitration to the Indian Arbitration and Conciliation Arbitration Act and made the venue London. Now, the English Arbitration Act has mandatory requirements in sections 2 and 4, where it clearly states that any arbitration happening here is subject to the Arbitration Act. And what the courts said is that the way they would interpret it is that the Indian Act would be the equivalent of a set of arbitration rules. And so that arbitration would still need to comply with the mandatory provisions of the English arbitration. And I don't think that's what parties particularly want. So I think the key thing and thank you very, very much to everybody who's said something, contributed.
Sorry, Amelia.
Yes, Prof.
If I may come in.
Please.
Yes. The guy who raised the question about May, yes, you are right, it's permissive. The proper clause should be mandatory. Then the issue of the president of the Charter Institute of Arbitrators, is that the name of our association in Nigeria? Then lastly, the issue of venue. This exercise was packed from 3 different references. We have the first main, what I call our local clause in Nigeria on pathological clauses. The case is Imokwede and Mokwenye. That is where the parties provided that the appointing authority shall be president, blah, 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 blah. Then there's another case of Sino-Africa Agric, where the word may was used. And the issue was whether that may was mandatory. Funny enough, the court held that that may is mandatory. And I like, they borrowed from Justice Aniagolu in Afolabi and Adekure, where he said, since parties are bound by the terms of their contract, they must also be bound by errors and mistakes they have condoned and waived. So what the court is trying to say is look at the intention of the parties. They opted for arbitration, so that the use of the word may should not be used to deny them that reference. Lastly, venue for arbitration. This is from P&ID. P&ID. We are saying that we should use the proper word. Both the Constitutional Modern Law and our ACA says place of arbitration, venue for hearing. So if we are drafting, we should provide for place for arbitration and venue for hearing. Otherwise, the English courts, we interpret clauses like this to mean that they have the seat. And that's what happened in P&ID. Emilia, thank you very much.
Thank you very much, Prof. Okay. So the key thing, again, we're trying to do when you get a clause, look, let's be a little bit systematic. So can you see any consent, any submission to arbitration? You remember what you're looking for. If you can see consent, can you see what it is? And in this second exercise, are there any prerequisites, and are they mandatory? Do you have to go through them before you can commence arbitration? And so you just make sure you go through them. Now, where you have inoperativity and incapable of being performed issues, it all depends on the courts and the courts that you go before, because quite a number of arbitration-friendly jurisdictions will find a way to send you off to arbitration, really. They will find a way to, but you don't want to risk that. And as Prof says, your starting point, you don't want to draft something that the parties would then need to start with arbitration. And really, for me, I get a little concerned because I think 2 or so of the versions that were independently drafted on the course this afternoon, on this workshop, talked about any dispute difference, and then in addition, you then added validity and interpretation and all of that. You've already said any dispute arising out of any dispute is any dispute. So, you know, remember that we have rules of interpretation. And so you don't want to be use too many superfluous wording that might just become a problem for you. Okay, so I think we are done. So remember the checklist. You will get the slides. Chinelo has the slides, so she will send.
Emilia, sorry again. I just forgot. The problem that was based on Lagos State. I want to remind attendees that Lagos State have their own arbitration law now. So bear that in mind. So whether you can be drafting in Lagos and provide for ACA as the applicable law. Two, the issue of seat, the issue of applicable law for now in Nigeria is not relevant in a domestic arbitration. It's when you go international that becomes a problem. So for a domestic arbitration, the issue of seat, the issue of, well, maybe language, maybe, but in practice, with that in English, I've not seen any contract in Hausa or Yoruba or Hausa. All the contracts I've seen are in English. For me, in a domestic reference, the issue of language may not be important, but the issue of seat is not relevant because the issue of seat in Nigeria may be it's Lagos or Abuja or Kaduna, but not sit in terms of tying the transaction to a particular legal system. Thank you very much.
Okay, so Prof, I have two different views. One is that the Lagos law, especially if the transaction is international, will not be the applicable law. The arbitration, the proper law of that arbitration will not be the Lagos arbitration law if it is international, because we have ACA. Remember that we are a federation. I know that there's lots of debate here and there. And I know that practitioners in Nigeria say that if you have an international transaction, you can say that your arbitration will be governed by the Lagos arbitration law. I don't agree with that. I don't think that that is the correct position of the law, because we are a federation, and internationally ACA is the Nigerian arbitration law, not the Lagos arbitration law, but that's a debate for another day. Then the second thing is, though it might be domestic, but remember that your domestic arbitration, which is what happened in IPCO and NNPC, which was a completely domestic arbitration, but you might want enforcement. And so enforcement, for you to bring yourself within Article 1 of the New York Convention, it has to be an arbitration that happened in a convention state that you're trying to enforce the award in another convention state. So IPCO is purely domestic, but enforcement was sought in the UK. So those are things to bear in mind. And I understand the point Prof is making, because if it's domestic, it is Nigerian parties, it's happened in Nigeria. But it's for purposes of the New York Convention, it's always advisable when you're writing that award to make it clear the nationality of the award. Okay.
Sorry, Amelia, I don't intend that we will debate this. Yeah, but we must draw a line between a domestic reference and international reference. The point I'm making is, when the reference is domestic, the issue of governing law will not arise, the issue of seat will not arise. It's when the reference is international. For instance, even if it's a Lagos State, we can succeed in making Nigerian law the governing law and not any other law of another country. What am I saying? I am saying that we must draw a line between a domestic reference where the issue of seat will not arise and international reference where the issue of seat will arise. Thank you very much.
Prof, I agree with you. But remember that your domestic award can be enforced under the New York Convention.
I agree, like in IPCO and NNPC. I agree.
I think we finally agree.
Yeah. Yeah.
So we've put together a couple of pointers for a checklist. You can just sort of, when you're drafting your arbitration agreement, to just keep knocking those off and just be sure of what it is you are drafting, so that the basics at least would be there. So we have saved 6 minutes for the closing tasks that we need to do. But the key message I think that we want to leave with you today is the arbitration agreement needs to be internally consistent. So we've seen the one that is not. The two that we had, we saw problems. The key thing is you want one message. You're sending one clear message. We want to go to arbitration over these disputes, and this is what we want. It needs to be clear. It should be certain, and it should be one that is capable of being performed. So thank you very much. Thank you everybody for contributing to the discussions and the knowledge sharing. So I'm going to hand over to Prof. Thank you. So that's it. Prof, you're on mute.
Chinelo.
Okay, indeed, no one does it better than Emilia does. I must say that this has been an edifying information. Thank you so very much for this great wealth of knowledge gathered today. Distinguished participants, your questions will be answered in the bits. If you have more comments, please post them, and then any of the moderators will do the needful. I beg your pardon, the alternate chairman of the Continuing Legal Education, Professor Peter Akpe, even though he says he doesn't want to say anything. Sir, would you want to lend in a few thoughts, say in 5 minutes? I know we are behind time. Please unmute yourself, Prof. Okay, I see he's not logged in. He's not logged in, so we'll just proceed. Professor Paul Idonige, the chairman, would you want to lend in more of your thoughts, or we should just proceed to the question and answer session?
No, I think we did. Sorry, we are not going to have a different Q&A.
Yeah.
We did Q&A as we went along.
There are questions in the platform.
Okay,
Emilia.
Questions
on the platform, Prof.
Emilia.
Yes, Prof.
Yeah, I think you can take the question before I do my vote of thanks.
Can I stop sharing my screen then?
Okay, fine, okay.
Yes, please. Yes, please. Okay, so at this juncture and in the next say 10 minutes, permit me to call on the co-moderator, Mr. Ogunti, to anchor the question session. Mr. Ogunti, some of the questions have been answered, so please just read them carefully before you pose the questions to Professor Emilia.
All right, thank you very much, my co-moderator. Good afternoon once again, everyone. My name is Samuel Oguntui. I have the pleasure to, having noted the questions by trainees for today, we have quite a flurry of questions for our distinguished lead presenter for the day. That's Professor Emilia Oyema. The questions, I don't know, I beg your pardon, Professor. Do I take all at the same time because of our time, or I just read them one after the other?
I think we've been answering.
Yeah.
Yes, some have been answered. Yes, some have been answered. Okay, we have about 3. Let me take it cumulatively, Prof.
Okay.
Thank you. The first one was asked by Kenneth Anoka, to which our distinguished Professor Idoni Jessian gave a very erudite answer to. The next question was asked by Mr. Matthew Adadikam. I hope the surname I got it correctly. And the question says, his question says, is it best to challenge an award before the courts at the place in which the award is rendered, or
wait to challenge the award before the courts of the state in which recognition and enforcement is sought? That is a question from Mr. Matthew Adadikam.
I think that's a question, we can quickly answer that. I think that's a question, my view is that that's a question of strategy. And because not all jurisdictions adhere to Article 5.1e. So if you go to the seat and they set it aside, that doesn't mean that somebody else will not attempt to go somewhere else, go to France and try to enforce it. And France, they're not bound by that original setting aside. I would not support a party waiting, folding their hands, waiting to when it is the award is being challenged, then they raise a defense. I think that if there is grounds to challenge an award, it's better to actively challenge the award and get it out of the way. Prof, do you have another view?
No, I agree with you because that raises the issue of seat. So for me, it's safer to challenge an award at the seat instead of waiting for enforcement. Then at that point, you're asking for grounds for refusal of enforcement. So I prefer that the award is challenged at the seat. Thank you.
Okay, thank you very much, Professor. I'm sure the person who asked the question should have his question answered by that very erudite response. The next question is from Mr. Oluwafemi Fadeyi. Mr. Oluwafemi Fadeyi asked, can Nigeria arbitral practice adopt the OHADA regime on arbitration? I think OHADA is an abbreviation for Organization for the Harmonization of Business.
Don't worry, Emilia lives in OHADA countries. Don't worry.
For the benefit of our listeners, Prof.
Don't worry.
No, so Nigeria cannot adopt the Uniform Act of Arbitration of OHADA because Nigeria is not a member.
We are not.
OHADA. So OHADA operates a uniform system of laws, but that applies in its 17 member states. So for us to adopt the OHADA regime, we will need to become a member of OHADA. And it's not only arbitration, the Uniform Act, you adopt all the Uniform Acts. And so my personal opinion on a wider question on whether Nigeria should actually join OHADA is absolutely no.
That's a very sharp and precise answer. We thank you, Prof, for that. The next question was asked by Mr. Jerry Musa, and I think this is a curious question, and it borders particularly on the names of parties. Now, he asked, why should arbitration, which is considered to have less emphasis on technicalities, consider a mistake in the name as completely fatal to the arbitration process? Shouldn't the pleadings cover for the error committed in respect of the name?
It just goes back to the consensual nature of arbitration. Again, remember that you can't force me to go to arbitration. And especially if I don't know who you are. If I've never had any transaction with you, why would you be taking me to arbitration? That's a short answer.
Yes, let me add to that. I was involved in a reference where my name was wrongly spelled. It was I was appointed by a court, and in the court order, my son name was wrongly spelled. Now, I started the reference. I invited the parties. I asked them if I was the one that the court appointed. They said yes. I finished the proceedings. I published an award. Then a party went to court to challenge the award on the ground that he is not the person that the court appointed that presided. So it's very important that you spell the name. Although the court, because of what I did at the preliminary meeting, I asked them if I was the one, and I documented all this in the records and in my award. But it's very important that you use the proper names of the parties and the arbitrators. Thank you.
Thank you, professors. That was quite illuminating. The next question. In view of Professor Emilia's response, I think this is a little tied to her response to the question just read. It's a question from Florence Nwosu, and she asked where parties consent to arbitration and there's a problem, and they could not settle the issue through arbitration. Then one of them resorts to litigation in court. The other party now refuses to the litigational process initiated by the other party. And in this instance, what should the parties do where one had gone to litigation and the other is unwilling to?
So I think we dealt with this in
Yes.
And again, the party that does not want to litigate, the ACA is quite clear. It says before they take steps in the proceedings, which basically means before they join issues with the other party. So before you file a full defense, they need to challenge the jurisdiction of the court. If they do not challenge the jurisdiction of the court, then they've repudiated that arbitration agreement. So they've basically agreed to proceed on the basis of litigation. So they need to ask for an anti-suit injunction.
Thank you, Professor. That takes me to the next question. This actually is the second to the last. He asked, the name is Nosinilo. Nosinilo asked, if you do not specify that, now in court, if you do not specify that in court, the parties agree that any dispute arising out of be submitted to arbitration, quotation closed. Can it be inferred that given that the agreement is between the parties, they are agreeing to that arbitration clause by signing the agreement?
My view would be yes, but that is a very pro-arbitration view because if it's a clause in the contract, so you can sort of walk your way back. But that is a tricky one because a judge can rightly say that it is not a clause that you can operate. So, you can put into effect. So it's better to look at your drafting, and let's just go back to that webinar, the one Prof gave on clauses, on drafting clauses and using boilerplate clauses. It's just going through it, being careful, be patient. Don't just copy and paste without calmly going through to be sure that you've covered the basics.
Okay, thank you, Prof. And that will take me to the last question. That's for the questions I have noted earlier. I understand there are other questions on the screen that's in the chat box, but from what I wrote earlier, Mariam Osiri asked, please, what is the best practice when parties to a contract are from different continents as it relates to the place of arbitration when disputes arise?
So personally, my personal opinion is if parties are, I'm going to revise the question a little bit. If parties are from different African countries, so they're from 2 or 3 different African countries, they must be able to find a 4th African country if they're keen on neutrality to situate the arbitration. That is massively important. There is no excuse to go export the dispute outside the continent. If the parties are from different continents, what usually currently happens is that they would choose a neutral venue. A neutral venue does not mean that it can't be a seat in one of the continents. And so if you think about it, most of Africa-related disputes would have a non-African, maybe a European, and they will still choose a European seat. And so it's really, it doesn't mean that it must be a third continent, as long as the parties are comfortable that the venue or the seat would support their arbitration. I think those are the key things to think about.
That's very profound, Professor. Thank you very much for that insightful responses. I don't know if I could go ahead to read. There are about 3 other questions that I can see on the chat box. I don't know if we have time to be able to take them.
Emilia, do you have time?
I can give another 15 minutes.
Okay.
Oh, thank you
Sam,
very
go
much.
ahead.
Okay, sir. We have a question from Jerry Musa. I think this is the second question coming from him. The question says, with the advent of arbitration process conducted from start to finish online, can we begin the discussion of having a cloud in quotes, seat of arbitration?
So let me speak a little bit about the delocalization theory, which was floated by Jan Paulsen, that I'm sure the vast majority of you in the room would have read something he's written. The idea that Jan Paulsen had is that international commercial arbitration floats. It does not belong to any jurisdiction because of its international nature. Not only is it transnational, it just has no location. And the supporting argument being that if you take the vast majority of arbitrations, most people don't even know an arbitration is going on. An arbitration happens, the award is given, the party, the judgment debtor pays up, and people get on with their lives. And so that, in his words, the arbitration floats. It is only when the parties require support of a national court or, a law that the arbitration crystallizes. It attaches itself to that jurisdiction. So even with ODR, online dispute resolution processes and mechanisms, and the fact that we do a lot of virtual hearings and all of that, that does not mean that the arbitration does not have a locale or, is not localized. It is localized because even the air, even if you're flying across and you're having your arbitration in a private jet, or you've become Jeff Bezos and the Virgin, and you're going to the edge of space. Countries own airspaces. You're flying over somebody's airspace. And so I think that whether it is happening in the cloud, whether it is happening on site, on the, with your 2 feet on the floor, and every arbitration is localized. And that's what that choice of seat does for us. It localizes that arbitration. And so that might be old school for now, but I still hold on to that that view for now. I don't subscribe to the fact that just because it is cloud or ODR, that it does not have a local. Prof, I don't know if you have.
Yeah, I share your view because the issue is, can arbitration survive without the support of the courts? So as long as you need the court for purposes of enforcement or for one relief or the other, an arbitration must have a seat. And so the seat performs that function. So even if we are not using Jeff Bezos, we're using, Brancy has a license for commercial flights now to go to space. So even if we are using Richard Brancy's commercial flight to space, I believe that arbitration must still have a seat for purposes of carrying out this supervisory role. Thank you very much.
Thank you, professors. Very profound. And that takes me to the next question here. I think this is a question relating to an earlier statement in the course of the lecture by Professor Emilia in respect of challenging and appealing an award. The question is from Pedro Ubene, and he asked, you said arbitration award cannot be appealed, but can be challenged. So can you shed more light on the difference between challenging an award and appealing the award?
Okay. So basically, the main difference is that you can't reopen an award on the facts, on the merits. Yeah. And so there has to be, there are limited grounds. Every law provides some grounds on the basis of which you can challenge. So either generally due process grounds, either there was no arbitration agreement, or the arbitration agreement was invalid, or you were not given an opportunity to present your case or to defend yourself, or the arbitrators were not properly appointed. Prof has given an example to that effect, or the dispute, the subject matter was not capable of settlement by arbitration. They're limited. I think the New York Convention has about 7 limited grounds on which you can bring yourself. So you can't, for example, go and say that you deserve to get 2 million when the arbitrator only awarded you 1 million. You know, it's not a ground. It's not one of the grounds. So you have to bring yourself within one of those grounds.
Okay, thank you very much, Prof. Professor Idonije, I don't know if there's a contribution in that direction.
No. Emilia has comprehensively covered the ground on that.
Okay.
Arbitration is not litigation, and courts do not have that role to look at the merits of how we arrive at our decisions. There are limited grounds for that. Is the major difference between an appeal and a challenge. There are limited grounds you'll find in the ACA. You also find in the New York Convention for challenging an award. Thank you.
Thank you, Professor. That takes me to the next question. I think this is from Mirabel and so forth. I think our guest presenter for today mentioned Madam Mirabel as being one of the lead lecturers in the UK. And the question from Madam Mirabel and so forth says, does a clause for arbitration prejudice or, I take it again. Does a clause for arbitration prejudice or affect any right, power, or remedy which has accrued or shall accrue to the parties?
Not in my view. Those are substantive issues which the tribunal would need to deal with. So the arbitration clause only goes to the forum where the dispute will be ventilated. And Mirabel is a solicitor. She's not an academic. So,
my apologies.
Just to but that would be my answer anyway.
Thank you very much, Prof. That was profound. And that takes me to the next question by Mr. Max Ikongbe. Mr. Max asks, sorry. My apologies. That's not a question. It's a commendation from him. We have a question from Lawrence Ohineme. Lawrence Ohineme asks, can a venue of arbitration be different from the seat of arbitration?
Yes. So remember that the seat of arbitration, we usually call it the juridical seat. So that all it means, parties might not even have any connection with that seat or even go there. But what it means is that that's the place that the law and the courts will provide support to the arbitration. The venue or place, so most most laws will talk about the seat and the place. The place of arbitration can be anywhere. So it can be in the cloud, it can be virtual, it can be in Lagos, And so you can have one of the clauses we looked at said the venue or the place of, let's change that to the seat of arbitration will be London. You can have your hearings in Lagos, wherever that you want. And the difficulty with the legal seat, whether you call it a venue or whatever, is that it's only the parties or the arbitrator or under some institutional rules that can change it, that can move it. It is static. So it's, but you can sit anywhere. You can have your place of arbitration anywhere. You can do anything you want.
Thank you very much.
Sorry, Sam. If I may come in,
okay,
I think the confusion is caused by use of language. In the ancestral modern law, place of arbitration is used. In our ACA, place of arbitration is used. Because of the confusion arising from the use of place and seat, ideally, the place referred to in the modern law is actually the seat of the arbitration. And so we arbitrators will take place to mean seat. What have we done? In the new bill before the National Assembly, we drew a line between the use of this word. So to avoid the confusion arising from, like I said earlier, the venue for arbitration, we drew a line between seat of, we are not using the word place in the new draft. We're using the word seat of arbitration and venue for hearing. Like Amelia said, look, you may have a hearing without reference to the seat at all, but you are concerned with where do you conduct the hearing. So legally, Nigeria can be the seat, but the hearing can be in UK, in US throughout, without any sitting at all in Nigeria. But what I find interesting is the day you publish your award, even though your hearing was in Washington, in London, anywhere, you are writing the award, assigning it in Washington, but when you get to place of arbitration, you will put Abuja, Nigeria. Meanwhile, you are in the UK, you are in the US. Thank you very much. Sam, unmute yourself. Have you finished?
At this junction, permit me to call you back again to give. Permit me to call you back again to give the closing remarks, Prof.
Okay. Let me.
Professor.
Okay. Let me, on behalf of the chair of the Unity Bar and the entire members of the bar, thank my friends. I don't know how to describe Amelia. My friend Amelia, I expected nothing less from her. I am sure that if we all read the material that we sent to you and listen to this presentation, like I said, her slides will also be sent to all those who registered, so that we want to ensure that, you know, our business is arbitration. If you take our business away from us to the courts, we'll be jobless. So we are trying to protect our territory to ensure that any draft that refers to arbitration, you mean arbitration. So I am sure that at the end of this training, you now know how to draft an effective and valid arbitration agreement. You can see, like I said just now, where the word may was used. Ordinarily, we say may is permissive, but the court said may can mean shall. And so they gave the tribunal jurisdiction. So we are praying for pro-arbitration jurisdictions that no matter how the court is drafted, they will refer parties to arbitration. But like I asked, why do you allow parties to go to court to sort out the issue of the clause? Why not take advantage of courses like this? Many of you are see Amelia free of charge, but for a training like this, I will not tell you ordinarily how much Amelia will collect, but we thank God for this platform. We thank God for the chair for allow us to share this kind of platform and to invite very distinguished arbitrators like Amelia. So Amelia, on behalf of all of you, all of us, we thank you for agreeing. You know, it's like a clause on arbitration. First, you must agree to arbitrate. Then, secondly, what is the scope of the arbitration? So first, we must thank you for agreeing to come. Two, for making this presentation. For the attendees, let me thank you for, we hope that you have benefited. We hope that you have gained from this series. We are available. If there are questions on this subject matter, Emilia will be willing to answer them after this event. I think what remains now is for me to say thank you to the moderators and members of my committee. I want to thank the committee members for the support. We'll have another training in August, and I'm sure that you will continue to support this committee. Thank you very much, and God bless.
Thank you. Thank you, Prof. That was brilliant.
Chinelo or Sam?
The profession, the exact education.
Okay. Chinelo.
And everyone who collectively put together this webinar. Thank you to our awesome guests.
I think the system is tired. So let me say thank you very much, and seeing you very soon in July. Thank you very much, and bye-bye.